We are live.
All right, excellent. Looks like we have a quorum here today. So good afternoon, everyone. Welcome to our work session on the Law Enforcement Officers Bill of Rights. Today we have three bills that have come before us. That'll be the basis for discussion. One from Senator West, another from Senator Casserly, and then one from Senator Carter. Our counsel, Jamie Lancaster, will run through each bill, kind of give the wave tops of what each bill does. And then since Senator Carter's is by far the most comprehensive, we'll use that as a basis for discussion, and we'll have the conversations with Senator Casserly and Senator West in parallel. Senator West's bill, I know that largely, as your term, cannibalized from what Baltimore County did, sets forth a lot of guidelines, but keeps in place the administrative process of the LEOBR largely. But setting a lot of guidelines. And then Senator Casserly, I think, models a lot what Harford County has on the books right now, which essentially prohibits the collective bargaining for those disciplinary rights. It just removes that from the process, but leaves in place LEOBR largely. So with that, we'll start off with Mr. Lancaster giving us the overview, and then we'll be able to go through kind of line by line, as it were. Before we Jamie, before you jump on, I do want to just set the tone for the rest of the week. So tomorrow we actually have a very busy day on the floor, obviously with veto overrides, and I think we have 12 bill hearings. We will do another work session on this police reform package, and then a voting list will be published either tomorrow morning or tomorrow afternoon that will have the following bills on the voting list. So MPIA, LEOBR, the mental health assessments, so Senator Washington's bill, and then part of a bill that I put forward a week ago, independent investigations and demilitarization. Those will be on the voting list and subject for discussion tomorrow during our work group. The voting list will essentially be the same for this entire week. So for Wednesday, Thursday, and Friday, we'll be discussing those bills. So as you can imagine, this entire week will be dedicated to just bill hearings, but then focused in on police reform. And then the following week, we will have we have 3 or 4 bills that will come up. We'll discuss those later on this week. So that's what our week will look like. And with that, Jamie, if you are up and ready to go to kick us off, we'll start off with you. Today we have a hard out at 5 o'clock, so we're not going to go any longer than 2 hours here, or an hour and 50 minutes. So hard out at 5 o'clock. Jamie, you're up.
Thank you, Mr. Chair. So there are 3 bills that are on the agenda for today. Just in order, these are Senate Bill 237, Senate Bill 381, and Senate Bill 627. Just going down the list, Senate Bill 237 was on the agenda last week on Friday. This is Senator West's bill, and one aspect of that bill requires the chief of a law enforcement agency to adopt certain rules. So it doesn't really affect the overall process of discipline for law enforcement officers, but with these rules, a law enforcement officer would be subject to discipline if they violated. So the rules are that each agency would need to adopt the following rules that demonstrate the highest regard for the sanctity of human life and value of all persons, to use only objectively and reasonable, necessary, and proportional force, to use de-escalation techniques when safe and reasonably possible, to intervene to prevent or terminate the use of excessive force by another officer, and also to report those interventions. They're also required to prohibit retaliation against officers who report these incidents, to render aid, to report physical force, injuries, or complaints of pain by a person in custody, as well as reporting the discharge of firearms. Finally, the rules would need to include a prohibition on the use of specified restraints. So moving on to the next bill, that's Senate Bill 381. This bill would prohibit a law enforcement agency or its superior governmental authority from entering into an agreement with a collective bargaining unit that was inconsistent with the provisions of the current LEOBR. Additionally, it would repeal authorizations for alternate procedures that were the result of collective bargaining agreements. And then finally, Senate Bill 627 is a little bit lengthier, and I'll just sort of give a step-by-step of overview of what the process is that it lays out. But first, it repeals the current LEOBR and replaces it with a alternative mechanism for disciplining police officers. This would begin with an investigation, and then following the investigation, the officer would receive notice of each offense that they're subject to discipline for, the possible disciplinary action that may be imposed, and the proposed disciplinary action. Following that, the chief or the chief's designee would need to give the officer an opportunity to identify contested issues of law and fact related to the discipline or the factual conclusions that supported it. If the officer requests so, the next step can be a meeting with the chief where the officer can raise any objections, additional evidence, or mitigating circumstances. And then 10 days after that meeting, the chief would either be required to determine and impose discipline, or if the chief found that there were contested issues, order a hearing to resolve those issues. So from there, the chief would then appoint a hearing officer who would conduct the hearing, and the hearing officer would then prepare findings of law and fact. The chief would then review those and determine the appropriate discipline. There are also appeal rights to the circuit court provided for in the bill. And at the very end of the bill, there's a provision that allows for a county or political subdivision to create oversight boards that would essentially take the place of the chief in the disciplinary proceedings. So they would have the powers that the chief does in these proceedings. So that's just a very general overview of the bill. There are, of course, other provisions, but I think that's a pretty general summary of it.
All right, excellent. Thank you, Jamie. So at this point, I want to give the sponsors just an opportunity to say something if they like. If not, I'd like to move to, and Jamie, help us walk through this. We could move through Senator Carter's bill and kind of go line by line. And I think there are a lot of the parallels with what West and what Senator Castley are proposing are actually incorporated into that larger bill. If we could go on to, if Senator Carter or Senator Castley or Senator West would like to say something. Senator West, you're up. Go ahead.
Thank you. Very briefly, when I put together my bill, I really wasn't intending to deal with the Law Enforcement Officer Bill of Rights. So it only tangentially bears on it. So really, there's no need to discuss my bill in this afternoon's conversation. I do want to say, however, that when I picked up the one drafted by Senator Carter, I apprehended the worst. And I've got to say that as I read it, I went page by page. I kept saying to myself, this is good. This is good. This is really good. So I am pleasantly surprised and pleased with Senator Carter's work. And I think it needs a little bit of tweaking, but in general, it's something I think I can live with very happily. I'm pleased that I didn't try to deal with it because I think Senator Carter has dealt with it quite well.
Well, that is music to my ears. I'm sure it's music to Senator Carter's ears. So, well, I appreciate that, and I agree. So, that's what we're doing this for. We'll go line by line, and we'll hear from in the future, in the coming days, we'll hear from the FOP, and we'll hear from the chiefs and sheriffs, and we'll hear from the ACLU and others as well. So I'll open it up. Senator Sidnor, did you want to say anything, or Senator Carter, Senator Castley? I'll unmute you, Senator Sidnor. There you go.
Can you hear me?
Yes, we can.
All right. No, I just been in communications with Senator Carter, and she was saying that she was having some technical difficulties with the Wi-Fi connection. So she is trying to get on, but is delayed. So that's all I wanted to bring to your attention at the moment.
Okay. Excellent. Thank you.
She gets on, I'll compliment her a second time.
There you go. All right. Well, then, Jamie, let's do this. Let's take this. And since then it is true that so Senator Castley's bill folds into an element of Senator Carter's bill with the preemption piece. But let's just do this. We'll go through each section of Senate Bill 627. We'll have a discussion, and we've got experts kind of in the waiting in our Zoom room here. So let's go line by line. If there's a point of debate or discussion or just inquiry, we can we can ask the experts, or we can talk amongst ourselves or ask counsel.
Sure. So getting into the meat of the bill, I think page 6 is probably a good place to start. At the top of the page, so lines 1 through 13, these are the preemption provisions. Provides that except for laws relating to an administrative hearing before the Maryland Police Training and Standards Commission, this subtitle supersedes any other law of the state, county, or municipal corporation that conflicts with the subtitle. It also provides that any local laws preempted by the subject and material of the subtitle, and that the procedures that are established by the new subtitle are the exclusive methods for disciplining a law enforcement officer. There's, as you mentioned, Mr. Chair, provision that prohibits a law enforcement agency or the agency's superior governing authority and a collective bargaining unit from entering into an agreement that's inconsistent with the provisions of the subtitle. Moving on, lines 14 through 20 deal with the burden of proof in proceedings under the subtitle. It provides that a law enforcement agency has the burden of proof by a preponderance of the evidence. It also provides that a law enforcement officer may be disciplined only for cause, and provides for transmission of documents to the parties. Another thing of note is in the next section, which is section 3104, the provisions require that an investigation be conducted. This would, of course, be in the case where the law enforcement officer hadn't been convicted of a criminal offense or received probation before judgment for a criminal offense. Turning next, I think the next page, page 7, lines 13 through 27 provide for the issuance of subpoenas in connection with an investigation. Following that, lines 28 through 32 are the lead-in language providing for the steps after an investigation is completed. So after the completion of an investigation, the chief or the chief's designee would need to notify the law enforcement officer of the offenses that they're subject to discipline for, the possible action that may be imposed for each offense, and the proposed disciplinary action for each offense. And there's language that provides for providing the officer with the investigatory file and any exculpatory information. If the officer and any representative of the law enforcement officer agree to a confidentiality agreement and to pay a reasonable fee for the cost of reproducing the investigatory file and exculpatory information.
Can we stop here for a minute?
Sure.
Okay. So the law enforcement officer, who I guess is the person who's being called up for disciplinary action here, apparently is being required to execute a confidentiality agreement. Certainly, if I were going to be subjected to discipline, I would want to be able to share anything I have with my counsel. This doesn't appear to contain a provision saying it can be shared with counsel. And then why would we want to make the law enforcement officer pay a fee? He's being investigated or she's being investigated. It would seem to me it should be provided free of charge.
Jamie, if you want to comment, and I actually had we had this conversation before, Jamie, but is this, a lot of this has been lifted, and this part right here, especially the fee piece, I know that's in LEOBR right now.
I believe that's correct, Senator. I'll want to double check to make absolutely sure, but I think we did have this conversation before, and I believe it is.
Got it.
Well, when I read this, I didn't go back to the existing law. I figured let's start from scratch and adopt what makes sense. So I don't think we should be bound by the language in the existing law. I don't understand why we'd make a law enforcement officer pay to get a copy of the investigation against him. And we certainly need to allow him to share it with his lawyer.
So it's funny that you say that. I actually had that exact same reaction and was like, no. So in the context of this federal employment law, like, you know, if someone is subject to an investigation, then they're not forced to pay. I mean, we had this exact same argument. And so, look, if it's a better policy call, I leave that to you all if you want to suggest something otherwise. There may be some history as to why that was put in there, but I'm not aware of it. So that's a point that we've definitely discussed before. So I feel the same way if you want to drop an amendment. But I do want to make sure that we have an opportunity. So this is a point here. You've got an FOP attorney, eminently qualified, and you also got Mr. Roca here. I do want to hear from, so Sandy, if we can allow for Mike Davey to respond to this, and then just for, and out of interest of equal time, have David Roca also chime in. But Mike Davey, you're up first, if we can allow him to speak.
They're joining. Give me 1 second.
Excellent. Thank you.
Thank you, Senator. I appreciate the opportunity. Senator West, in this section, it is currently drafted or copied right out of the Law Enforcement Officer's Bill of Rights. The file, we have to sign a confidentiality file, both the accused officer and the attorney. Basically, the rationale for that is simply that we cannot then in turn use that file to come back and sue someone or bring civil action against the department or for a witness in the case. But it already is something that the accused officer can share with his attorney. Even though it's written and pulled exactly out of the LEOBR, that is pretty much practically how that works. And why an officer is required to pay a fee. Most agencies don't charge a fee. Some do. Doesn't make any sense to me, especially with the bills that are coming in now regarding MPIAs. If citizens can get these investigations, the officer should certainly be able to get it to defend themselves. Thank you.
I couldn't agree more on that one. So maybe Jamie, can you make just a parenthetical note there for us to drop an amendment to address that? Okay. Thank you, Mr. Davies. So thanks for hanging tight. I'm sure we'll come back to you. Mr. Roca, did you want to chime in on this? Just out of the interest of just balanced response. So Sandy, if we could let him in the room. There you are. Ms. Roca, you good? Or do you want to?
Sorry, I was having trouble unmuting. Thank you, Mr. Chairman. On this specific point, I don't know that there's much to add. It is taken verbatim from existing LEOBR, and as to whether fees should be charged or not, I would defer to, that seems like something, I don't think we have a strong position on that one way or another. I think that's an issue that the chiefs and sheriffs may have something to say. But that particular piece of it has not been a focus for us. This was simply taken verbatim from existing LEOVR.
Excellent. Okay, great. All right. So Jamie, let's keep moving then.
So starting with lines 28 on down on page 8, provides that unless the law enforcement officer has been convicted of or received probation before judgment for a criminal offense, before the chief or the chief's designee may impose a disciplinary action, the chief or the chief's designee shall first review the entire investigative file and next give the law enforcement officer the opportunity to specifically identify in writing any contested issues of law or fact related to the proposed disciplinary action or factual conclusions supporting the determination that the law enforcement officer committed the offense or offenses for which the officer is subject to disciplinary action. Moving into line 7 on down, this is section 3105. If requested by the law enforcement officer, the chief or the chief's designee is required to meet with the law enforcement officer and consider any objections to the investigative findings and the conclusions supporting the determination that the law enforcement officer committed the offense or offenses, any additional evidence, and any mitigating circumstances. If the proposed termination for the law enforcement officer, or excuse me, if the proposed discipline for the law enforcement officer is termination, the chief is required to be the one that meets with the law enforcement officer, and the chief's designee may meet with the law enforcement officer for any disciplinary action other than termination. So,
Jamie, just real quick before we keep going, Mr. Davey or Ms. Wright, and same thing with the FOP. If you all have, an issue with something that's being read over, please, raise your hand and so we can discuss it now. That'd be great. I know we'll be doing more of this, but don't be shy. Please raise your hand. All right. Sorry, Jamie. All right, hold on. I see some hands.
Maybe had something to add.
So do we see Neski? So let's, Sandy.
Yep.
All right. And then Kathleen, is your hand still raised? And I think I know this Kathleen from Montgomery County, but I'm not sure if it's the right one, the same one. There he is.
Okay, I think I got this figured out.
There you are. Good to see you.
You as well, sir. Very quickly, I do just want to, again, repeat our overall support for the bill. I think it gets a lot of things right. We do have a few small amendments. One of the things that we were worried about or wanted to talk about was the general definition of crime. So if an officer is charged with a crime, probation for a judgment, or convicted of a crime, any crime at all, that takes them away from the hearing process. I think the stance of the chiefs and sheriff is that we'd like to see that narrowed just a little bit to serious misdemeanors, anything that's carrying a year or above. So, to be on the absurd side, I get, charged with jaywalking or something a minor infraction. That takes as an officer, that puts him right out of the hearing process. We'd like to kind of see that more towards serious offenses, of course, felonies, but maybe misdemeanors with a year or more of a penalty. I just think that the crime, just general crime, is probably a little too generic at this point. Thank you.
Thank you. Now I want to now give just again for balance, Mr. Roca. We had this discussion as well, actually, when I was reading this one, but I'll let Mr. Roca respond and then I can tell you how our discussion went just with council. But Mr. Roca, you're up.
Thank you, Mr. Chairman. Yeah, we would strongly oppose that. And I think the objection may be based on a misunderstanding of the bill and of the role of the hearing process. So the purpose of the so-called hearing under the bill is to resolve disputed facts when there is a question as to whether X happened or not, whether X is true or not. And where there is a conviction, there is proof beyond a reasonable doubt that the crime occurred. And so there is no longer a need, nor should there be an opportunity. There is no longer a need to establish that fact, nor should there be an opportunity after, once it has been proven beyond a reasonable doubt, for an officer to have a second bite at the apple to contest whether that occurred or not. The sole question then is what, if any, discipline should be imposed on the officer for the underlying conduct at issue in the criminal conviction. The answer may be none. The answer may be that the punishment is trivial. The answer may be that the punishment is severe, but that is a question for the manager to decide based on whatever mitigating evidence there may be, whatever the officer's acceptance or non-acceptance of responsibility may be, et cetera. But the purpose of the hearing is to establish facts. If there's a criminal conviction, those facts have been established, and there should be no narrowing of this provision and no relitigation of those facts.
Jamie, go ahead.
I just wanted to, based on that discussion, flag maybe a potential issue that the committee could clarify on. The language says that unless the law enforcement officer has been convicted or received probation before judgment, but there isn't language that necessarily confines that to the offense that they're being disciplined for. So that I'm not sure if that's maybe part of the exchange that's going on here, the concern about it, but you know, potentially, and this may seem absurd, but a broad reading of it could be that if they've ever been convicted or received probation before judgment, then they wouldn't be it. I just wanted to flag that because it was up for discussion.
Mr. Roca, go ahead and respond. And then I think, Sandy, we could find out who Rebecca Smith is, but Mr. Roca, go ahead.
Yeah, I mean, that reading sounds strange to me, but I guess I understand the potential concern. And certainly I was not attempting to suggest that if an officer is convicted of X, he or she can be disciplined for Y because of the conviction for X. I did not mean to assert that. I would never assert that. I don't think that's what the language here allows. But if there's clarifying language to make that clear, I don't imagine that we would have any objection or concern about that. Again, I think the purpose of the provision is to say where facts have been established beyond a reasonable doubt by conviction, there is no need, nor should there be an opportunity to relitigate those facts in an administrative disciplinary proceeding. And that should apply to all crimes. And it doesn't mean that, you know, a traffic ticket gets you fired. The penalty is based on the department's rules or and what the appropriate punishment should be. But the facts of whether the offense occurred should not be relitigated.
Understood. Yep. All right. Thank you, Mr. Roca. So Jamie, you're on page 6, lines 21 through 26. Can we just flag that for a potential clarifying amendment? I do want to make sure, just again, in interest of balance, then we'll move off of this. So we have Rebecca Smith from the Maryland Troopers Association. Sandy, Ms. Smith has something to add here. I'd like to hear what she has to say, and then we'll move off of this. So Ms. Smith, go ahead.
Hello, sorry about that. I couldn't unmute myself. Rebecca Smith from the Maryland Troopers Association. The main issue, and I just wanted to be upfront with this, is we're starting to enter into the amendments to 3-104. The Maryland Troopers Association has a big problem with all provisions regarding interrogations being eliminated from this process. And we just want to be clear that the implications under Garrity is that there will be no transparency and no statements being given by any police officer as part of any investigation with the way that this bill is drafted.
Sorry, writing down notes here. Okay, Jamie, thank you very much, Ms. Smith. I'm sure we are going to loop back to that in a few minutes here. Senator West, go ahead. You've got a question.
Yeah, thank you. Yes, I do actually. So I'm glad that our attention was called to this provision. I've read it carefully as we've been discussing it, and look, the first two sentences, or the first two lines, seem to refer to, it's in the past tense, unless the officer has been convicted, then there's going to be this disciplinary proceeding. So here's my hypo, and I wondered how this bill deals with it. A law enforcement officer is alleged to have committed, let's say, a serious misdemeanor. And so while this process is beginning, the state's attorney indicts a law enforcement officer for having committed the misdemeanor. Then what happens? I don't see that the bill provides what happens. Does this proceeding stop in its tracks while the criminal proceeding proceeds? Does the criminal proceeding have to stop while this proceeding proceeds? In which proceeding are the facts determined once and for all? Maybe Mr. Roca can answer that, because I don't see it in the language in the bill.
Thank you, Senator West, for the question. The bill doesn't specify, nor do I think the bill should specify, just as under current LEOBR, there's no specification either. So as contemplated by the bill, a department, if an officer is charged following an investigation, a department could, but would not have to, await the outcome of a criminal proceeding. If the department decided to proceed administratively while the criminal case was still pending, which is something that they could do right now, they would have to be careful of Garrity rights, as was just mentioned. And what that is referring to is the fact that if an officer is compelled to give a statement, which is different than simply being asked a question, but if an officer is compelled to give a statement in an administrative proceeding, that compelled statement cannot be used in a criminal proceeding against the officer, because to do so would violate the officer's Fifth Amendment right against self-incrimination. So many departments, just to be safe, will postpone administrative proceedings until the conclusion of criminal proceedings, but they don't have to. And Garrity does not preclude asking officers questions. It does preclude forcing officers to give answers. So the short answer to your question is, just as is true under existing law, an administrative proceeding could proceed in parallel with a criminal proceeding, but would not need to. And an administrative proceeding could await the outcome of a criminal proceeding. And if the result in the criminal proceeding was that, sorry, not sure of the correct grammar, was that the officer was convicted, then again, there would be no need to relitigate those underlying facts in the administrative proceeding, because they would have been determined beyond a reasonable doubt in the criminal proceeding. And the question would be what is the appropriate discipline, if any, administratively for the criminal conduct that has now been proven beyond a reasonable doubt. Does that answer your question?
I think it does. The original question was raised a while ago, and that was, shouldn't there be some kind of a cutoff? And below the cutoff, you'd have things only handled in the disciplinary area, and above the cutoff, you'd have the courts, the state's attorney doing it in the criminal. And I guess your response is the best way to do it is just to leave it where it currently is, which is if they start down similar parallel tracks, the disciplinary proceeding could stop in its tracks, literally in its tracks, to wait for the criminal proceeding to conclude, or could continue in parallel with the criminal proceeding. I guess then you've got a race to see which one ends up first as to which one determines the facts of the case, right?
Senator West, though, I mean,
the
sorry, go ahead.
Sorry,
No, go ahead. I want you to respond, but like, just in my conversations with, I mean, we got law enforcement on here, but the administrative piece will usually freeze while the criminal piece proceeds.
That would be my expectation.
Yeah,
right.
I mean, and just
but this doesn't require it to freeze.
Correct, but practically speaking, I think that's what's happening on the street right now. But Mr. Rocca, sorry, go ahead. And then I want to get it to Ms. Kruger, and then I want to move off of this. But Ms. Kruger is next. But Mr. Rocca, go ahead.
I apologize. I forgot what I was going to say in the immediate response, and so if I remember, I'll raise my hand again.
Oh, sorry about that. All right, Ms. Kruger, we're going to have you chime in if it's responsive to Senator West, and if not, we'll keep chugging along here.
Yes, thank you, Mr. Chairman. I think you can hear me, but I'm not sure you can see me.
We can hear you, and we cannot see
Okay,
you.
can I go with just the hearing for now?
That sounds good.
Oh, no, I can start.
There you go.
Gosh,
There you go.
these demands are pressing. I just wanted to take the opportunity quickly on the issue of the compelled statements that Ms. Smith brought up and that are also related to this discussion about the criminal prosecutions. That is, in fact, one of the amendments that the chiefs and sheriffs have proposed, that provision that exists in the LAOBR now that gives agencies authority to compel the officer to participate in an interrogation, that be imported into this bill along with the necessary immunity provisions. So I didn't want to miss my opportunity to just point that out. Thank you.
And we have that in the bill file. So thank you.
Where would that go? And what does Mr. Rocca think about that?
You asking Mr. Rocca that question?
Yeah, I think it's a fair statement. If it's not in here, and you're right, I didn't read it in here. Again, I didn't start by reading the original. I started with this.
Yeah.
So if there's an issue about compelled statements, which is not here, where would it go in the bill? And what does Mr. Rocca think about adding that provision in here?
I believe that the existing LEOBR has provisions regarding compelled statements, compelled tests, but has a provision that says that those cannot be used in a criminal case. I need to double check those. Assuming my recollection of that is correct, I don't think we object, subject to double checking refreshing my recollection about the specific provisions at issue, because again, we are certainly not arguing for any abrogation, nor could we argue for any abrogation of officers' Fifth Amendment rights. So anything that is compelled as part of an administrative proceeding is immunized from use did I say that correctly? Anything that's compelled in an administrative proceeding is immunized from use in a criminal proceeding, and that is as it should be. So if the chiefs and sheriffs believe that existing provisions that allow for compelled administrative testimony should be put in, then I think we would support that. I think it's probably mostly relevant to third-party witnesses where in an administrative proceeding, a third-party witness can be compelled to testify, just as is true in a criminal proceeding, without any Fifth Amendment implications. And that should be available in these proceedings. So I don't think we have any objection to that amendment.
I wonder, since Senator Carter drafted the bill, was there a reason why the compelled testimony of the officers was left out of this, whereas it has up until now been in the LEOBR?
Senator Carter, you're up. I think I'm unmuting you. Go ahead.
Thank you. I'm sorry, Senator West. What was that?
I'm sorry, and I know you're new to the conversation. So the some of the law enforcement community thinks that that this bill should contain the same provision that's in the existing LEOBR, requiring compelled testimony of police officers in connection with these disciplinary hearings. And we understand that it's not in this bill. So the question is, why was it left? Was there some special reason why it was left out?
I don't think so. I mean, I don't think it was intentional that I'm aware of.
Okay.
Got it. Well, Ms. Kruger, I'm looking at the testimony that was submitted, and it is a bullet point here that you've covered in your submitted testimony, but I guess the specific language isn't there, but maybe we could work with you on that language if you're still here, but you just give a thumbs up or something like that. But we could work with you on that language because there you go, I see you. So we'll have counsel reach out because I see the bullet point, but I don't see the,
Yes, of course. And I'd be happy to work with the Troopers Association and Mr. Davey on coming up with language that's agreeable to all, if that would be helpful.
Excellent.
Okay.
All right, Mr. Lancaster, you're up again. Let's keep rolling.
Thank you, Mr. Chair. And just a quick follow on to that exchange. If you look on page 14, and Mr. Rocco may have brought this up, I may have missed it, but provides that a chief or a chief's designee may suspend a law enforcement officer without pay and suspend the officer's police powers on an emergency basis if the law enforcement officer is charged with a crime. Law enforcement officer who's suspended under this section is entitled to the prompt completion of disciplinary proceedings under the subtitle. So I just wanted to flag that for the committee based on, I believe it was Senator West's question.
Got it. Ms. Rocco, you had your hand raised. You're good, or are you?
That was the point that I was going to make earlier in
Got it.
immediate response to Senator West's question.
There you go. There you go. All right. We're glad we got it.
So going back to page 9, so at the top of the page, lines 1 through 6, this is where the law enforcement officer has the opportunity to identify and write in
Jamie,
issues.
sorry to cut you off real quick. Jamie, we have a Senator Hettleman has a quick question, and I want to get to it first, and then we'll move on.
Thank you so much, because it was right on that point. So the page 14, line 1 through 7 that Jamie just read, does that need it all to be tied to when it says prompt completion of disciplinary proceedings? I mean, what happens if the trial goes on for some length of time?
It's not clear from the language. I guess prompt is probably a more subjective word, but if the committee would like, I'm happy to try and alter the language in an amendment.
I think that also is from existing law. It's just that existing LEOBR is narrower in that it applies only to an officer who is charged with a felony who is allowed to be suspended without pay. And I think the answer is if the criminal case goes for a long time and the agency has decided to hold the administrative proceedings in abeyance pending the outcome of the criminal case, then it waits.
Right, but is this a new power that's given to the chief to suspend
No.
without pay? And
No, well, Sorry, I didn't mean to cut off the question.
No, I guess, so I'm just thinking, so something quite egregious happens and the chief in his or her determination decides that they want to suspend the law enforcement officer without pay and on an emergency basis. And then I'm just sort of wondering if there needs to be some sort of clarification if then the law enforcement officer is charged with a crime and we're waiting for the criminal justice proceedings to conclude. That could be a chunk of time. And so I'm just looking at the provisions of C and wondering how they can be complementary.
So I don't think any change is necessary. And I think the answer to your question of whether this is a new power or not is that it is sort of a new power. So that's what I was trying to explain before. So the power to suspend without pay is not new. It exists in the current LEOBR. And there is the same provision saying if suspended without pay, the administrative proceedings should be prompt. And in the current LEOBR, it is the power to suspend without pay is explicitly tied to an officer who is criminally charged. But in the current LEOBR, it's limited to an officer who is criminally charged with a felony. So an officer who is criminally charged with a misdemeanor, and there are many very serious offenses that Maryland law classifies as a misdemeanor because of our, let's just call it funny system for distinguishing between felonies and misdemeanors, including excessive use of force, which would be an assault. That's a misdemeanor. The well-known example of the officer who was staging evidence on body cam video, that was charged as a misdemeanor, misconduct in office. So many serious offenses are misdemeanors. Under current LEOBR, an officer who is charged with a misdemeanor cannot be suspended without pay. So this changes the law, and it says any criminal charge can be suspended without pay. It doesn't have to be, but can be, but it is otherwise unchanged. So I don't think any further amendment is necessary. And if, as you suggest, Senator Hellman, the criminal proceeding takes a long time, well, the criminal proceeding takes a long time. And if the department has chosen to postpone administrative action until the conclusion of the criminal case, which they can do but don't have to do, and then the administrative action would be postponed during the duration of the criminal case.
So I get that.
Presumably.
Go ahead.
All I was going to say is that.
Sorry, keep going, but I want to cut this off very shortly here because I've got a long line of folks I want to get in on this, but keep going, go ahead.
The last thing I was going to say is that presumably then after the criminal case has concluded, the administrative proceeding should proceed quickly, which it could be because we won't have to relitigate the facts.
Right. I'm just, for that very reason, I'm just wondering whether C is necessary.
I think it was simply taken from existing law. I defer on whether it's necessary or not.
Thank you.
Excellent. Okay, thanks. So I want to make sure before, as we have Senator Bailey's next, then Senator Jackson, then Senator Sidner. But before we go to you, Senator Bailey, I did want to give, I think, Mr. Davey, did you have, I want to get Mr. Davey in, and then I want to make sure that Mr. Boatwright has an opportunity to chime in as well. His hand is raised.
Thank you. Just so we're all clear and on the same page, under the current Law Enforcement Officers Bill of Rights, a police officer can be suspended without pay if he is charged with a felony. Whether it be on duty or off duty, it doesn't matter. Under this provision, under 627, it'll now give chiefs the ability to suspend a police officer without pay if they're charged with any crime whatsoever. So while I trust many police chiefs, I don't trust them all. So now we're going to have an officer who may not be well liked in his department by the chief, who gets a speeding ticket in Virginia, and he's now going to suspend his police powers without pay, which not only affects the officer, but affects his entire family. We would ask that you consider a provision to this section where an officer is charged with a felony, he can be suspended without pay, or a crime committed in the performance of his duties. Limit it to something that happened while he was doing his job. So felonies, doesn't matter on or off duty, a misdemeanor or an other crime other than a felony, make it so that it has to be done in the performance of their duty. We get a lot of cases where certain neighbors don't like their police officer neighbor, and next thing you know, criminal charges are being brought against that officer for trespassing, for harassment, for all sorts of things. Currently under the law, if a police officer is accused of a crime by a citizen, that citizen has to go to the commissioner, and the commissioner cannot issue a charging document against that officer unless it's reviewed by the state's attorney. There is a checks and balance. Going this way, there is no checks and balances. The police chief would have unfettered ability to suspend somebody without pay for the most minor issue that may have come up off duty. So the FOP would obviously request an amendment that if you're going to suspend somebody without pay, it be for a felony or any other crime committed in the performance of their duty. Thank you.
That's definitely a point we need to talk about, just because, as was brought before, just some of the misdemeanors are pretty serious, and so they do have some sort of a bearing on your ability and, frankly, your credibility in the law enforcement profession. So I think we should talk about that more. I think that there's got to be a balance there. I don't know, in my mind what that is, but okay. So then I do want to. Let's see, Mr. Boatwright, I think you were next, and you've been waiting for a while, so I want to make sure you get an opportunity to speak.
Thank you, Mr. Chair, members of the committee. Is my audio good?
You're good, and your video is good.
All right, thank you. Thank you. Mr. Davey stole a lot of the thunder I wanted to bring up on the particular point, the particular topic at hand. However, I want to give this committee some insight into why we feel so strongly about this bill. Let me give you a few dates. Well, just a few years. 1974. Why is that important? That's the year the Law Enforcement Officers Bill of Rights was created. 2009. Why is that important? That was the date that the Federal Department of Justice found that the Baltimore Police Department's commanders were inappropriately levying discipline against their minority police officers. 2020, Prince George's County Police Chief resigned because their police department and their commanders were giving discipline to minority police officers at a heavy-handed rate. So at this point, we have this bill before us that gives our police chiefs the ability to discipline our police officers when they have shown. The reason that we have a Law Enforcement Officers Bill of Rights is because prior to 1974, our police chiefs were not consistent with handing out discipline. And so now we're going to go back to these days of giving police chiefs the authority to oversee our police officers. There's a reason why groups like the Vanguard Justice Society, like HOLEA, like the Blue Guardians, there's a reason why these groups exist. It's because our police chiefs have given our in some cases, minority and protected classes officers harsher discipline than others. So I think we need to tread lightly as we go about this legislation, because our police chiefs need to be able to give our police officers a fair and due process hearing. And that hearing can only happen after the investigation is complete and after the criminal charges are complete. So I thank you for the time to speak. Mr. Davey is our expert on these issues, and I'll defer the rest of my time to Mr. Davey.
Excellent. Thank you very much. All right. We're going to Senator Bailey. We've been waiting for a while, so you're up next. Then we have Senator Jackson, then Senator Sidnor.
Thank you very much. I will have to say, Mr. Davies and Mr. Boatwright both brought up very valid points. I was just wanted to say that the percentage of people that are charged with a crime versus the percentage of people that are convicted is significantly different when we talk about just the regular public. And so we know that that's going to be different when we talk about this with dealing with police officers. An open-ended issue like this is quite frankly, that an open invitation for discrimination, not only against protected classes in a police department, but police officers. This needs to be fair. One thing I would say is, what happens to the officer who's convicted or charged with a crime? He's not convicted, but as we all know, and especially if we were in that situation right now in COVID, where trials are being extended for months and months and months, that you're sitting there not getting a paycheck, your family is completely, has no way to pay the bills. What happens when you're not convicted? There's nothing in this bill that says, well, you're given back all your pay and all your benefits for that time. So that's enough said. Thank you.
Those are excellent points. Appreciate it. Perspective. Let me see. Senator Carter wants to respond directly, and then we're going to jump up to Senator Jackson and then Senator Sidnor. Sorry, go ahead.
Thank you, Mr. Chair. Actually, I was imagining that others might have expressed what I was thinking, but I think I just want to make the first point that the administrative and criminal processes are still different. They're not, one is, while the criminal charge can have an impact on the chief's discretion to suspend or not suspend, the ultimate outcome of the criminal case is not determinative of whether or not there's going to be an administrative disciplinary finding. And so I don't think that the way that you said it, Senator Bailey, it kind of sounded like just because the criminal charge might be dismissed, that was going to be that was going to be determinative for the administrative process. So I just want to make that point. And the other point I wanted to make, I forgot, going back to, it may not be a necessary point, but just that I wanted to make it clear that while I agree that there's been a lot of discrimination within policing, and personally, I've had a relationship with a lot of members of Vanguard Justice Society and worked with them closely over the years. In fact, it was they that asked me to put in legislation to modify the Law Enforcement Officer Bill of Rights years ago. They felt the trial boards were unfair, not the chiefs, but the trial boards. And so I think that it's important to note that even under LEOBR and even with the trial board system, Black officers and women officers have felt extremely discriminated against with the process. That's it.
I appreciate your comments, Senator, but I will have to say, when we're talking about somebody, quite frankly, just charged with a crime and not getting a paycheck, right? And it could be a misdemeanor of any degree, right? This just because the chief might not have some issue about what they have done in the past, or some reputation that they might have, whether it's a bias or not. That this, quite frankly, is not fair.
All right, excellent. So just a little disclaimer here, there's a leak in the office here. So if you hear flushing and water and all that stuff, that's what that is. So just have to put that out there. All right, well, look, I mean, Senator Bailey, I struggle with this too. I mean, same thing with Senator Carter. Look, the gambit for misdemeanors ranges, right? It's just like for everything, and we were talking about this before, it's like everything from, I'll just quit, I mean, a speeding ticket to child porn for, so it's like, I mean, you've got a whole gambit of crime that falls within that. So I don't know what the right balance is. That's a policy call that this committee is going to have to entertain as we move forward. But we will go to Senator Jackson. You are next, and then Senator Sidnor.
Thank you, Mr. Chairman. And I guess this question is posed to the sponsor of the bill. And I hope there'll be further discussion about what's included with suspending of an officer without pay. I've had the occasion to be an officer, an FOP president, and then the sheriff. And so I guess I'd like some further understanding of why we need to take this additional step in matters, and what has changed or what has caused the sponsor to put this in the bill.
A couple of things. Oh, yeah. So a few things, and I think you're just generally talking about the added discretion for the chiefs to suspend without pay absent a felony conviction. I think that's the crux of the question or the issue. And I would say that a couple of things. One, over the years, as we've had a lot of various bill hearings on different aspects of LEOBR and allegations of police abuse, one of the most compelling problems on the part of the public that has complained about officers have been that they've remained on the force with pay throughout the course of the process, and that's a problem for them. But in addition to that, I want to make it clear, and that this is discretion. This doesn't say that a chief is required to suspend without pay. It gives the chief discretion, and I think they have the power of discernment to ascertain whether the allegations, I think currently under LEOBR, the standard is something like if the allegations serve, if the officer, the suspension is based on whether or not the public interest or how it impacts the agency and how it impacts the public interest. And I think those are still good criteria for the chief to make a decision as to whether or not something warrants the suspension. I also want to say that, I am certainly the person, if you know me, that understands that there are such things in this world as false allegations. But in any administrative process, like all of the other administrative processes that are not outside of the policing, if it turns out that there was no merit to it or it's not founded in any way, then generally the officer or the person, the public employee, is restored to the place that they were before the process, before the allegations. And so that wouldn't be different here. Does that help answer your question? Also, briefly, just as Chairman Smith said, so I don't think a speeding ticket would rate, because it's not technically a misdemeanor, it's a civil offense. But I would say that there probably are some very minor civil offenses that may not rise to the level to warrant a chief to contemplate or even issue a suspension. But I also think that the chiefs have discretion in these cases to determine whether or not it's important enough to do it. And, the misdemeanors, as Chairman Smith said, run the gamut from domestic violence to those that impact the officer's duty, especially the misdemeanor assaults. So I think those are important.
Oh, there it is.
Is there some room? I think so, but I still think I would lean toward allowing the chiefs to have discretion in those instances.
Yeah. All fairness, speeding can be a misdemeanor, so can first-time child porn, possession of child porn. So it's a huge range. So again, it's a balancing act we're going to have to figure out. But Senator Jackson.
So I appreciate your response. So the allegations on, if the allegation, the way it reads currently, and again, having been in these circumstances in the past, if it's something that's, could be of a severe consequence to the agency. So are the chiefs and sheriffs requesting this, or is this the public's perception that an officer who may have been alleged to have committed an act is still on an agency? So I don't know who I'm posing that question to, but I think, there are certainly some circumstances where, there's some tough conversations that have been had over the years, regarding the misdemeanor in question. So I guess, so are we talking about the public's questioning or the chiefs and sheriffs questioning, or a combination of both?
I'll just answer for myself and let anybody else elaborate. Chiefs and sheriffs specifically did not request this. However, they have voiced the desire over many years in different bills to have more authority in these instances. But no, my concern is more for the public interest. The atrocities that have occurred with officers continuing to be on the force. And, I'm not going to reiterate stories that we've heard over the years, but there are many. where, you know, officers have been accused of excessive force and they've still been there. And while that was being investigated or not investigated fully, they've committed other offenses while still on duty, on pay.
I look forward to the dialogue going forward. So,
I'm
Thank
happy
you.
to, really. Just don't want to take up the time with reiterating the stuff we've heard.
This is great. This is good. All right, so I'm going to do Senator Sidnor and then Senator Castle.
Thank you. You can go ahead to Senator Castley. My statements. I'm good now. Thank you.
Excellent. All right, Senator Castle, you're up.
Yeah, so I think I would just like to posit that a lot of these concerns that Senator Carter just addressed about really egregious cases being left unattended to would be addressed with just one simple change, and that's allowing the chief to have the final say ultimately. And perhaps if the FOP wanted, we could always allow for an appeal to alleviate their concerns that perhaps the chief would be grossly unfair, and we could certainly allow an appeal to the, you know, either the court or to the Office of Administrative Hearings to make sure people's constitutional rights weren't being trampled upon. But this is what the whole reason the reason I put my bill in is I was very concerned as I look at the discussion here. There was a lot of legal energy put into developing LEOBR, and the problem that we're doing now is to try to rewrite this thing in a couple of weeks that was written over years with tons of thought and with the solid bodies of common law now developed based upon that. And that's a real problem when, you know, normally the way we would legislate is to remove the most obvious flaw and then keep working backwards to see when the problem stopped appearing. So for example, we're talking about the provision on making a misdemeanor or felony, what have you, determinative of the officer's guilt. Look, that we already have a substantial body of law on this, and I'm not sure. I think we would agree that we don't want to treat police officers better, but certainly not worse than the general public. And what we're looking at here is the general body of law of when do we give collateral estoppel, non-mutual collateral estoppel for a criminal matter into a civil case. There's already law on that, and we don't have to buck that just in the case of the police officers. And we want to take a look about what is the normal collateral estoppel effect where you have non-mutuality in a criminal to a civil case. Let's not rewrite the law on this just to go after the cops. Why wouldn't we apply the same law to cops that we apply to everybody else in our society? So that would be an easy one to address. But I am concerned. I would like to hear so much more from the police officers' side. I mean, we have a bill that was written by the ACLU, and so we know what their position is on virtually every letter, every comma, every period in this bill. We know it passes them. What I'm really curious to know is what sentences, what commas, what periods do the police officers feel is violative? What hurts them? I mean, we got to run this by. So I have all the ACLU input. I got it. I know exactly what their position is on everything here. It's there in that bill. But I would certainly love to hear from you folks in the law enforcement community, you know, exactly what sentences, what commas, what paragraphs in this bill you say is, I really don't care about it. That's fine. You want that? And which ones you find just not fair, not appropriate. And so, Mr. Chairman, I would just love to hear more from them as we, you know, almost take us through the bill themselves on what they feel is wrong, so we can know, because I haven't heard a whole lot from them. I realize that the process here trying to get everybody in, but I'm hearing more from the ACLU on their views about their own bill than I am from the police view about the ACLU bill. So thank you.
Thank you, Senator Castle. I'd take exception to that. I'm trying to provide, you know, a balanced discussion here, so, and make sure that everyone's incorporated equal time. So doing our level best here, that's for sure. Mr. Neske, you're up next, and then I see that Mr. Davey has something to say.
Thank you, sir. I'll be very brief. Senator Jackson, you want to know kind of where we stood on the on the misdemeanor side of things. One of the things that we've tried to do, and our philosophy from the very beginning of this session, has been to try to take what we're seeing and try to take what legislative things are brought our way and make them fair and operational to the best of our ability. And one of the things that we looked at was some of these provisions on how do we make them operational and fair to the officers. And that's what we were trying to do by raising that to a very serious misdemeanor category versus an entire, set of crimes. So again, we're trying to walk that line of how can we try to be as fair to the officer and not put an undue burden on them while trying to also be fair to the managerial side and make the punishment or the process worth the offense. So that's how we got to the very serious misdemeanor level.
Excellent, thank you. So Mr. Davey, and then I'm going to go to Mr. Roca, and then we're going to tie a knot on this one and keep moving, Jamie. So Jamie, I don't even remember where we left off, but let's find that point and we'll keep going after that. Mr. Davey, you're up.
Thank you. Just 2 quick points. I think what, again, is another misunderstanding, that if, say, a police officer is charged with a crime, he's suspended out without pay 4 or 5 months before he gets a trial, he's then found not guilty. The process doesn't stop there administratively. Most of the time, a police agency will then file administrative charges against that officer for the exact same violation and take them to a trial board, because the standard of proof in the criminal case versus the administrative case is much less. So he's found not guilty of, say, assault in the district court. The agency will then charge him administratively and then take him to a trial board under the standard of a preponderance of evidence in an attempt to then discipline him that way. So that's just a point of clarification how the actual process works throughout the state. And Senator Castley, as to your comment, the FOP has prepared a 4-page line-by-line breakdown of this bill with our opinion and the rationale, what we see as problems. I will ensure that that gets emailed to you tonight, and I'll be available anytime you'd like to have a phone call, and I can walk you through each one of those lines. Thank you.
And Mr. Davey, for the record, you and I have been on countless Zoom calls going over this stuff, so and more to come, but we've definitely, we'll go on this. We'll keep working.
And I appreciate any time I can get on this issue. I understand the importance of police reform. The FOP understands it completely. All we're trying to do is make sure that there's a process in place that is fair to the officers. I find it somewhat ironic, in all honesty, that in Senate Bill 178, Mr. Roca says we can't trust the police because we need to have disclosure of all internal affairs cases. We don't trust the chiefs that they're doing fair investigations and thorough investigations. And now we flip over to Senate Bill 627, and they want to give the chiefs all the authority in the world. So they don't trust them when it comes to the public, but they do trust them when it comes to the law enforcement officer. I struggle with that. Thank you.
So we're going to move on to Mr. Roca, and then we said Senator Bailey and then Senator West. And then we do need to move on. So Mr. Roca, you're up.
Thank you. There's a lot of things that have been said that I want to try to respond to. So first, I think Mr. Boatwright was recounting the history of the LEOBR in his view, and that we shouldn't change it because it would allow for discriminatory discipline. I want to point out that the 2020 case that Mr. Boatwright referred to is a case that the ACLU brought against the Prince George's County Police Department. And we are indeed quite concerned about discriminatory discipline. And I have personally worked with the Vanguard Society and other officers around the state concerned about discriminatory discipline. But nothing in this bill will make discriminatory discipline more likely. It protects officers' legitimate due process rights. And as the case Mr. Boatwright referred to, the existing LEOBR has not prevented discriminatory discipline. As to this question of whether being charged with a crime should allow a department to suspend without pay. I would agree that a criminal charge that does not relate to an officer's ability to perform their job should not allow them to be subject to discipline. I'm not sure immediately what those charges would be, but I think it is, I think as Senator Carter was saying, in existing law, and I think it would be fair to say that certainly with respect to misdemeanors, the criminal charge should relate to the officer's ability to perform their job. But we should also recognize that that's an extremely broad category, precisely because officers are the representative of the state and have to be unimpeachable. And when they are facing criminal charges, that becomes, at the very least, very difficult. Similarly, even traffic offenses, officers have, in many, if not most departments, have to be able to drive a police vehicle. If they can't do that, then they can't perform their job. And then I want to respond to quickly to what Mr. Davey just said about some inconsistency in our position, and I don't think it's inconsistent in the least. I don't think it's inconsistent at all. I think there is substantial mistrust of whether chiefs are adequately disciplining officers for misconduct. But this bill seeks to remove impediments to adequately disciplining officers for misconduct. And if the chiefs don't, and transparency over whether the chiefs are or are not adequately disciplining them for misconduct is necessary and critical to holding them accountable for adequately disciplining officers for misconduct. The two are not inconsistent. They are inextricably intertwined, and both are necessary. Chiefs have to have the power, and they have to be accountable for that power by making those decisions transparent.
Okay, thanks. So we got, I see you, Senator Castley. Senator Bailey, Senator West, Senator Castley.
Thank you. And I'll just go back to Mike Davies' point about how long the criminal and administrative hearings can take when you are actually a police officer. Now, when you talk about the furtherance of somebody's career, right? You talk about you're taking promotional tests. You're taking a test that comes up to further your career. And between the two, between the criminal and the administrative hearing, we're talking year or more. If you're suspended for a misdemeanor violation that the chief all of a sudden decides, you know what, for these violations, we're going to do it. Even though you're not guilty, right? You can never go back to what you lost, because during that process, you're never going to be able to go back to the fact of and compete against those people. You're going to fall out of line. You're going to be behind. All of a sudden, for a potential allegation that is just that, it's an allegation. You weren't convicted, but yet your career is taking a back seat behind it. There is a true injustice with this part right here that we need to think about and moving forward. And by the way, the code of conduct for police applies 24/7, whether they're working or whether they're not, whether they're on duty or not. So that's it.
Appreciate that. Thank you, Senator Bailey. We'll move on to Senator West and then Senator Castley.
Thank you, Mr. Chair. It's just a quick request, and that is when Mr. Davies' objections or suggestions for changes in this bill arrive, I assume he would send a copy to the committee. I think the committee ought to send them to each of us, because
I'll make sure we do that. If Mr. Davies is comfortable with that, you said that, I'll make sure we get it to you. If you send it to me now, I'll make sure the committee gets it like in the next 10, 15 minutes.
That's it. Thank you very much.
All right, Senator Castley.
Thank you, Mr. Chairman. A couple of points. One, as we look at this issue of you might have a policeman sitting there collecting his salary, who maybe is pretty widely acknowledged to be guilty of a crime, and they're sitting there on the force, pulling in taxpayers' dollars, taxpayers' benefits. I just remind this body that we had a member of our own Senate sat on the floor for an entire term when everybody knew that he was on audio recording, taking a bribe, and yet that person was allowed to sit in the Senate, collect a salary, get full benefits for a full term. So this is not unprecedented. It's sort of, we all work that way, and maybe sometimes it's inconvenient, but that's what we do to make sure the potential criminal prosecutions come out okay. But I don't think it's inconsistent. The other issue I have is the amount of due process that we give a police officer should not be geared towards public perception. I mean, the police officers do as much due process against the accuser as they are against the person making the final decision. And clearly the public would like us to say, hey, you can trust the chief if he wants to fry the cop. But the police officers, the amount of due process they got, we should not set up a system where the amount of due process we give a police officer depends upon our desire to have a good public perception of the amount of discipline or oversight we're providing to the police force. That's just that would be a big problem, because due process is supposed to be the process that's due to ensure the credibility of the system, to protect the individual's rights against unfair prosecutions, unfair trials, unfair outcomes. That's what the due process is about. And that's not tied. Hopefully that amount will provide public confidence in the system, but we don't gauge it upon, well, when the cop's addressing the public, it's one amount. When the cop's addressing the chief, it's another amount. The amount should be the amount appropriate to protect the officer and protect their rights, their constitutional rights, and not just simply vary because we're trying to gain public perception in one area and not in another area, right? Thank you.
Thank you, Senator Castley. Intimately familiar with that case study because that was my first year in the Senate, and I was constantly ducking out of the picture frame when the newspapers were covering that, that topic. But I suppose we could have voted, check my Senate rules to expel that individual. But all right, let's keep moving along. So, Mr. Lancaster, are you back up?
Yes, sir.
All right.
So I've got us at page 9 in lines 8 through 16. So this is where the law enforcement officer has an opportunity to come in and meet with the chief to discuss any objections, additional evidence, or mitigating circumstances. As I mentioned before, if
hey, Jamie, sorry to interrupt you again. Hey, Jamie, sorry about that.
Sure.
Senator Carter had her hand raised. I want to make sure I get Senator Carter's comment quickly.
It's okay, Mr. Chairman. I was actually just going to put a note in the chat to the panelists, and it was just addressing what you or someone suggested about Mr. Davies and his proposed amendments. I just wanted to make it clear that I think you should send something to the committee, but I'd like for you to articulate them now while we're going through the bill as well, but not necessarily just once we're finished with the hearing, just go through part by part and amendments for things that we haven't discussed. That's all.
Excellent. Yeah. So I guess we'll work from this point forward. If they have comments, please, obviously as before, just please raise your hands and chime in. All right. Sorry about that, Jamie.
Thank you, Mr. Chair. So if the proposed action is termination, the chief would be meeting with the law enforcement officer. Anything short of termination could be the chief's designee. Within 10 days, the chief needs to determine and impose disciplinary action, if any, to be taken against the law enforcement officer, or if the chief finds that there are contested issues of fact relating to the proposed imposition of the disciplinary action, order a hearing within the provisions of the subtitle. So the bill provides that the law enforcement officer may have a representative attend the meeting with the law enforcement officer. It doesn't actually specify that this needs to be an attorney, so that could be any form of representative. The meeting needs to have a written audio or video record. This is page 10, lines 1 and 2. And if the chief imposes a disciplinary action, the chief or the chief's designee must provide the law enforcement officer with the decision to impose the disciplinary action in writing. The written decision needs to include a summary of the facts and evidence used to conclude that the law enforcement officer committed the offense or offenses that they are subject to discipline for. So moving on to, this is page 10, line 11 down. If the chief or the designee determines that a hearing is necessary, the chief shall order a hearing to make findings of fact in the matter. The chief is to appoint one person who is not involved in the investigation of the allegations of misconduct against the law enforcement officer. This person would serve as the hearing officer to preside over the hearing. The chief or the chief's designee is required to give notice to the law enforcement officer of the time and place of the hearing and the contested issues of fact to be determined.
All right, Jamie, we've got Jamie. Let me go ahead and grab Mr. Davey here and Ms. Smith.
Thank you. Just in the section that Mr. Lancaster just went through, please understand that the way this bill is written, the chief decides if an investigation is going to be done. The chief has an investigator do it, whether it be sworn or civilian. The chief just then gets the investigative file, and the chief decides whether there's a contested issue or not as to whether you're going to get a hearing or not. There's no oversight, there's no transparency, there's no accountability for anyone other than the chief making these decisions. If the chief decides, well, there's no contested issue in my mind, and considering internal affairs works for him, what are the chances of you're going to get a hearing? And if you do get a hearing, we are now going back pre-2016 in that it's a one-person trial board or hearing officer. There's no 3 people, there's no civilians. Again, there's no transparency, there's no civilian oversight, and there's no accountability on the chief. In our opinion, that is not fair due process for the disciplinary system. Thank you.
And to add on to what Mr. Davey just said, with this whole process with what's now being called 3105, where is the officer's right? You can present additional evidence. Where's the right to cross-examine witnesses, to ask questions of people that were already questioned during the investigation? So the chief's given all this power to make these decisions without hearing the evidence. It's a violation of due process.
Excellent, thanks. Mr. Roca.
It most certainly is not a violation of due process. In fact, it's more process than any other public employee would get. So I think we need to be clear about a few things. First of all, Mr. Davey says it's not transparent, yet the hearing is open to the public, just like current trial board hearings are open to the public. Yes, the hearing is one person, but there is no constitutional right to the hearing being held by more than one person. And one person is sufficient to perform the role that the hearing provides, which is to resolve disputed questions of fact. For any other public employee, if they had their cross-examination rights through a hearing before the Office of Administrative Hearings, there would be one person presiding over that hearings who would make findings of fact and conclusions of law. Here, the hearing officer is performing only the fact-finding function. Conclusions of law are left to the chief where they should be, and they are making recommendations to the chief. There is no constitutional entitlement to have someone other than the chief be deciding disciplinary questions. That's why the bill leaves the decision to the chief. That is the person who should decide. And as to confrontation rights, that is that Ms. Smith asked about, that is expressly and precisely the purpose of the hearing. If there are contested issues of fact, then the officer is allowed to cross-examine witnesses, call witnesses, et cetera, at the hearing that is contemplated by the bill.
Excellent. So I want to give Mr. Davey or Mr. Boatwright an opportunity. So you're deferring. I'll give Mr. Which one? All right, Mr. Boatwright. Sorry, Mr. Davey, you're up.
Thank you. Mr. Roca is correct. You do get a transparency in the hearing if the chief gives you a hearing. He's not required to give you a hearing. Basically, this hearing process as written is nothing but illusionary. The chief gets the file. The chief makes a decision, you can have a hearing. He picks the hearing officer. The hearing decision is proposed and it goes back to the chief to decide whether he agrees with it or not. I don't even know why in this bill you have a hearing the way it's written, because basically the chief can do it all. Why don't we just give the chief the whole investigative file, bypass the waste of time of a trial in which he makes the final decision anyway? It's illusionary. It's not due process. There's nothing independent in that process whatsoever.
Excellent.
Sorry, I get a little heated with these things.
No, this is
very
really
passionate.
This is exactly what we need to happen here. Is that both sides are here, and we need to hear this dialogue. So, Ms. Roca, your rejoinder.
The hearing is not pointless. The point of the hearing is when there are disputed facts. If there are no disputed facts, look, I understand what Mr. Davey and the FOP want. They want someone else other than the chief to have to decide whether or not the officer is going to be punished. But it is simply wrong to say that there is a constitutional entitlement to that. There isn't. And I have to say, I don't even think that's a debatable question. The Supreme Court case law is quite clear. An officer can be disciplined by a chief without any hearing at all. Now, I want to be clear about something else. Officers, like anyone else, part of due process is confrontation rights. That is the ability to confront the witnesses against you. And the purpose of the hearing is to vindicate the officer's confrontation right. But that right does not require that the hearing take place after discipline, nor does that right require that the chief be the person who conducts the hearing. I mean, we also have to remember the chief is also supposed to be running the department. So the chief doesn't have the time, him or herself, to be personally conducting these administrative hearings. That's why a hearing officer is appointed. But there is nothing in due process that requires that person be completely separate from the chief or overturning the chief. And in fact, the fact that the hearing here is taking place prior to the decision as to whether or not the officer will be disciplined is giving the officer additional protections beyond what the Constitution requires by granting them those confrontation rights prior to the imposition of discipline. It is true that the more common scenario, and the scenario that's laid out in the state pension and personnel article, and that it's common in a number of local jurisdictions, is to have the agency head leaving aside now, I'm talking not about police officers, but other public employees, is to have the agency head make the final decision prior to any confrontation rights being vindicated, prior to any hearing where witnesses can be called and cross-examined. But this bill, in order to have a focus of accountability, grants those confrontation rights prior to discipline being imposed, but it grants them only when there is a fact question to be resolved. If there is no fact question to be resolved, then there are no witnesses to confront. And yes,
So I want to move on to if we could briefly conclude, because I want Ms. Smith to have an opportunity, and then I know Senator West has a question. So I want to, if you could briefly conclude.
Yeah, just I'm sorry, I lost my train of thought again.
Sorry, I keep doing that to you, but we'll come back to you then. Just when it comes back, we'll come back. So Ms. Smith, go ahead, and then Senator West will be up.
With the proposed 3-105, the chief is the one making the decision as to whether or not there is a fact in dispute. That's the main issue that Mr. Davey just raised, that the police officers have with this. And when you get down to it, you're giving this very large power to the chief of police to make all of these decisions with respect to what's going to happen in these files without any oversight. And what happens when the chiefs are the monsters that you fear with respect to this lack of transparency and all of the issues that are being raised and are being brought up with the police reform bills? You're giving the power to one person in every department.
All right, excellent. Thank you, Ms. Smith. All right, so very briefly, Mr. Roca, and then we're going to hop over to Mr. West, to Senator West.
Yes, that's true. The chief does decide, and that's why transparency is important, so that the chief can be held accountable. And I want to say one other thing. This is the point I was going to make at the end, which is this claim that there is no oversight is incorrect. If an officer believes that the chief has erroneously denied them their opportunity to confront the witnesses against them, or has reached the wrong conclusion, either on the facts or on the law, they have the power to appeal the chief's decision to the circuit court, just as they do now under the LEOBR.
Okay. All right. We're gonna give Mr. Davey the last word on this, and we're gonna go, because I see the handshake. Then we're gonna let you get the last word, and then we're moving on to Senator West.
Thank you. Let me just, two things. Let me give you an analogy. Compare this bill to a criminal case, and we'll just look at it that way. You have an individual charged with a crime. They elect to have a jury trial. But before that jury trial starts, we're going to give all the evidence and all the transcripts and all the testimony to the judge. You have your jury trial, and the jury of your peers finds you not guilty. But then the judge stands up and says, you know what? I've already read all this. I don't agree. I'm going to find him guilty. That's not due process. That's not fair due process. Mr. Roca continually says police officers should not be treated any differently. The last time I looked, an administrative aide from the Maryland State Police doesn't get their name in the newspaper when they get arrested for DUI. They don't get their name in the newspaper when they do something wrong. Giving the police chiefs the overreaching authority to simply discipline people for what I would believe is in their best interest, because that's what this is coming down to. If we get a bad case or a bad set of facts or a bad body-worn camera, the chief immediately is going to move to discipline that officer, and they're going to do that because they want to be the chief next week. Without an investigation and without any hearing, the only thing that holds a police chief accountable in the disciplinary system is two things. The ability for an officer to have a hearing, independent of the chief, and that hearing decision of not guilty being final. And that's two things that this bill eliminates from the due process system. Thank you.
Thank you. All right, thank you, Mr. Davis. We're going to go to Senator West and then Senator Casserly.
Thank you, Mr. Chair. So I've listened to this conversation with interest. I think that Mr. Davey makes a good point that it sounds like the chief is involved making decisions at every step along the way. And ultimately, after this hearing occurs, the chief's going to make the final decision. So it all comes down to the chief. So I wondered, we have administrative law judges. In the federal agencies, we have IGs, inspectors general. Couldn't we create like an independent group of people who are familiar with policing, who would serve as these hearing officers and would go from county to county as needed to preside over these hearings, and have an independent person make decisions and then make a final recommendation to the chief? It seems to me that would be a better solution than having the chief designate someone under his control who's going to serve as the hearing officer. Just an idea.
So just to be clear, like an independent charging board that would review charging decisions, and is that what you're saying?
Yeah, someone who is independent of any particular chief. So for the Baltimore County Police Department, it would be someone who is not under the control of the chief of police of Baltimore County, who would be the hearing officer, who would hear it independently and hear all the evidence and make a recommendation at the end of the hearing.
A binding recommendation, or?
No, it would come back to the chief. The chief ultimately is responsible. He has to make the final decision. So I think the chief ought to do that. Mr. Davey might disagree, but at least the hearing would be conducted by someone independent who would be trained, who would be familiar with police procedures and therefore wouldn't come totally unawares, and would be trained in being an impartial arbiter.
Interesting. All right. Senator Castley, you're up.
I feel like again we're making an issue out of something that needn't be, because in the counties where the hearing board is established as just without being an arm of the union, just a hearing board, the chiefs don't have a problem in appropriately disciplining people. It's just not an issue. The problem arises because the chief isn't the final decision maker, because the final decision goes to an arbitrator. And we're coming at this problem when we should be coming at it with a scalpel. We're coming at it with a freaking chainsaw. As a chief, you want a hearing board. Mr. Chairman, you sit on the military side of stuff. These boards take a lot of time. If you're going to do a board right, it takes a lot of time. And if you're the senior officer or leader who's been charged with running one of these boards, it's going to shut you down for a week, maybe two, as you prepare for it and do all your work and then write up your results. So you need a good board that's going to actually listen, deliberate, ask the right questions, chomp through the facts, do the subpoenas, what has to be done, and then presents the chief with a solid report based with their findings. If we do that, I think you're going to find that the major jurisdictions where all the problems are will have just as much faith, the citizens will have just as much faith as we do in the jurisdictions where LEOBR original is actually still followed. And so I would really just implore the body to look at this thing again with a scalpel and not a chainsaw. You do want a hearing board as a practical matter. Yes, you do. You want that because it just doesn't work not to have that. And you want a fair hearing board that's got some senior people who can dedicate a week or two, not every week. Otherwise, your chief becomes nothing but he or she is totally consumed just by discipline. I mean, that's all they will do is be the discipline chief. So you want these competent boards. And as long as we provide for a fair a process where the choice of the boards gives the, includes the chief as well as the accused officer some fair input, you'll get a good board. And if they're not, we can always come back and amend for a particular county. And then the chief has their responsibility, as you would for, say, a general officer, to take the court martial's recommendation and impose the proper punishment. But this is the analogy really fits because it is a quasi-military operation here. And we do have the same issues of motivation and fairness I mean, the analogy with the military system is very strong. All the rationales, and I just feel like, why are we in Maryland totally recreating the wheel when you can go to every military post, whether it's Air Force, Navy, Marine, Army, and look at how we do these things appropriately. You can go to police departments around the country, but you can also just simply go to every police department in this state and see what's working and what's not working. And I would submit to you that in those jurisdictions where the collective bargaining agreement has not totally sidetracked the disciplinary process, they're not having problems. And we're just going off on a wild, this is just unnecessary that we're coming at this way. Thank you.
I appreciate it. Thank you, Senator Castley. Senator Carter, did you want to?
Not necessarily. It sounds to me like Senator Castley and maybe some others are wedded to the current process of the necessity of a trial board. And, many, many years ago, I remember proposing an independent trial board so there would be less bias. As we know, trial boards are currently appointed by the chiefs. So to some extent, the chief does have control even in the current process where we have trial boards. I just think that in the interest of time, we should, if we're going to have a full-blown debate over the efficacy of trial boards, it should probably take place outside of this meeting so we could try to get through the bill more.
Noted. Okay, so we'll, with Jamie, if you're ready, we can continue on. I saw Mr. Boatwright and Mr. Roca. We'll continue on and we'll get to you.
Hey, Mr. Chair. So we're on page 10, lines 22 on down. This provides for subpoena issuance in connection with the hearing and the service. It needs to be served in accordance with the Maryland rules. Into the next page, in lines 5 through 8, provides for the hearing to be open to the public unless the chief finds that the hearing must be closed for good cause, including the purpose of protecting the identity of a confidential informant, undercover law enforcement officer, or a child witness. I believe this is actually verbatim from the current LEOBR.
Yeah, Jamie. All right, this is going to be our last issue for the day because we do have a hard stop at 5. Senator West has a question, and then we'll move on to. I thought Ms. Kruger had something, but Senator West, go ahead.
Yes, this was the subject of the objection to the Maryland Judicial Conference, which I think makes some sense. I missed it earlier when we were on page, I think it was page 7 or 8, but it comes up the second time here, and that's at the top of the page. It says if a person fails to comply with the subpoena issued under this subsection on petition to the state court administrator, a circuit court may compel compliance. The Court of Appeals points out that the state court administrator does not accept circuit court filings and petitions, and is really not a judge. He's a clerical person. So it's a technical point, but when we get around to amending the bill, we need to take out the term state court administrator and substitute a more appropriate term here.
You got a thumbs up from Senator Carter. She's already identified that. So I think she's already working on a solution. There you go. 2 thumbs up. All right. Ms. Kruger, did you have something to say? Go ahead.
Yes, thank you. Just very quickly. I don't know if I missed these couple of things in the lead up to the hearing. There's something about witness expenses, and I just wanted to point out the chief's and sheriff's desire to amend that each party shall bear its own witness expenses, as well as if we could look at a provision for reciprocal discovery, limited reciprocal discovery, because the agency has to give all the information to the officer, but the officer doesn't have to provide anything, notice of the documents or witnesses that he may present in his defense. Now that may become redundant if they've already had the meeting and the officer has produced documents, but it's something we'd like to look at. And then lastly, on this open meeting provision, I actually remember testifying about this when it first came into the LEOBR, and the three specifics, confidential witness, undercover law, or child witness, those were just examples that I sort of came up with on the spur of the moment. So really that provision should be a little bit more expansive to say for good cause shown or for good cause such as, and list examples, because there are some other areas in which closing a hearing would be necessary and appropriate. Thank you, Senator Carter. She gave me a thumbs up.
Yeah, thanks. Jamie, I'm going to move up to Senator Bailey, unless you had a comment you wanted to make on that.
Just to one point that Ms. Kruger made, the term including generally in the code is just used for illustrative purposes. So I think actually in the general provisions article, we provide for that. So the term good cause would be more encompassing than the CI or undercover officer or child witness.
Excellent. Okay. Thank you for that. Senator Bailey.
Thank you, Mr. Chairman. I'd just like to, I know we are running out of time and it looks like we've got 2 minutes. I'd just like to say that as we started here with 106, if we get down to the bottom of that page on page 10, I think there is a definite worthwhile discussion that we talk about, because the hearing officer is limiting the right of the officer to bring witnesses for their own defense and forcing the officer to provide information that could be key in their defense. When we look at lines 28 to 31, I know that it's 5 o'clock. We are right at the end of the day, but I really would like to have this be a discussion point as we start back over with this, because I do not feel that this is fair at all. Thank you.
Well, thank you for that, Senator Bailey. And with that, so we'll Jamie, just make a note. We'll start on page 10, line 11, 3-106 tomorrow. So you noted tomorrow we've got another session, and then we've got tomorrow, I'm sorry, we've got after our veto overrides, we've got Wednesday, Thursday, Friday are basically work sessions / voting sessions. So we'll have an opportunity to continue this conversation as a committee. This will be limited to the committee members. So obviously folks will be live streamed, but committee members only. Okay, so I will see you all tomorrow on the floor. Thank you all. It's been good.